Welcome back, friends, to this Nani Palkiwala Wednesday Law Club special show on 64 leading case laws for AOR examinations. Friends, now we are in session 4. We will see case number 49 to case number 64 in this last session. So, case number 49. Jarnal Singh and others versus Lakshmi Narayan Gupta and others. This case was decided on 26 September 2018. Article 16, 4A, 4B, 335, 341 and 342. This case is on reservation in promotions. So reservation is promotion, Jarnal Singh case. Constitutional bench, 5 judges bench, Constitution of India, Article 14, 4A, 16, 4A, 16, 4B, 335, 341 and 342. Interpretation of reservation in promotion. Judgment in Yam Nagaraj case. Correctness of referred to 5-judge constitutional bench. Held, judgment in Yam Nagaraj case does not need to be referred to 7-judge bench. However, the conclusion in Yam Nagaraj case that the state has to collect quantifiable data showing backwardness of the scheduled caste and scheduled tribes, being contrary to the 9-judge bench in Indra Sauni case. Is held that to be invalid to the extent Constitution of India reservation, principle of creamy layer, principle of creamy layer. Remember that word. Application to scheduled caste and scheduled tribes held when a court applies the creamy layer principle to SC and STs, it does not in any manner tinker with the precedental list under Article 341 and 342. Caste or group or subgroups named in the said list continue exactly as before. It is only those persons within that group or subgroups who have come out of the untouchability or backwardness by virtue of belonging to the creamy layer, who are excluded from the benefit of reservations. Constitution of India, Article 14, 16(1). Reservation principle of creamy layer held. Creamy layer principle sounds in Article 14 and 16(1) as unequal within the same class are being treated equally with other member of that class. So this is very good decision of this court, and many more things are there. This will not be possible if only the creamy layer within the class bags all the quoted jobs in the public sector and perpetual themselves, leaving the rest of the class as backward as they always were. So this case goes in favor of the backward class and scheduled caste and scheduled tribes to come over from that caste systems or from that backwardness. So equality among that class, that is important principle here. So equality among class. Suppose if there is discrimination between creamy layer and backward class, this is not equality class. But when there is a discrimination between backward class and backward class, that is infringement of Article 40. If there is a difference between a scheduled tribe and scheduled tribe, that is Article 40 infringement. So this is a very important concept and principle. Now case number 50. Cause title, Joseph Shine versus Union of India, September 27, 2018. IPC, Section 497, Offense of Adultery. Section 198 of CRPC, 5 judges bench. Indian Penal Code 1860, Section 497, Section 198 of CRPC, offense of adultery, whether unconstitutional, being violative of Article 14, 15, 16, 28, 21, held by this Apex Court, Section 497 IPC and Section 198 of CRPC, being violative of Article 14, 15, and 21 of the Constitution are unconstitutional. Section 497 treats women subordinate to men. The rationale of the provision suffered from the absence of the logicality of the approach and therefore suffers from the vice of Article 14 being manifestly arbitrary. Section 497 also creates individual distinctions based on the gender stereotypes, which creates a dent in the individual dignity of women and hence offend Article 21. Offense of adultery under Section 497 does not fit into the concept of crime. If it is treated as a crime, there would be the image of instilled into the extreme privacy of the matrimonial phase. Section 198 CRPC deals with the procedure for filing complaint in relation to the offense under Section 497 IPC, and hence it is also unconstitutional. Similar opinion are given by different judges also. So very interesting case to read. Those who love the criminal law, I love all law. कौन सा law ज़्यादा अच्छा लगता है? I don't have the answer. I love criminal, I love civil, I love property. But very good exercise you will get in property matters. Property matter ka, if one judgment, I got the judgment on that day, one case is coming with me of property matter. तो वो ये judgment मुझे समझने में उसका जो 1970 onwards, generation to generation, this has passed away, this is legal hair, then addition, liquidation, till this date. So this is very hard to synchronize. So property matter is giving a best mental exercise and very less mental exercise in criminal matters. So I'm not discriminating it. I'm telling about the positive aspect. Criminal matter can be easy to handle, and property matter is best for your mental exercise. So all other matter is between this property matter and criminal sanction when justified. It is also discussed in this case. Now, case number 51, leading case, Competition Commission of India versus Bharti Airtel Limited and others. December 5, 2018, Competition Act 2002, Anti-Competitive Agreement. 3 telephone company trial. Two judges bench. Competition Act 2002, Section 14, 19, 21, 21A and 26. RJIL filed information under the Act alleging anti-competitive agreement, cartel having been formed by the three major telephone operators, along with the COAI. Grievance of RJIL was that the IDOs intentionally ignore its request to augment point of interconnection POIS for access, national long distance and international long distance services, as the capacity already provides to it was causing huge POI congestion, resulting in call failures on its network. Apart from IDOs, certain allegations were made against COI also. It was alleged that IDOs were denying mobile number portability, request of the customers who wanted to switch to RJIL competitive service, and that COAI was acting as the behest of IDOs against the interest of the competing members, that is RJIL, and not for the common interest of the industry and consumer as a whole. CCI held that prima facie case existed and investigation was warranted, and directed Director General to the cause of investigation in the case. Jurisdiction of CCI to deal with the matter was challenged by IDO and COAI. Held by Apex Court is that as the TRI is constituted as the expert regulatory body which specially governs the telecom sector, the said aspect of the dispute are to be decided by the TRI in the first instance. These are jurisdictional aspects. TRI being a specialized sectorial regulator and also armed with the sufficient power to ensure fair, non-discriminatory and competitive market in the telecom sector, is better suited to decide the said issue. So this is the outcome of this case. The Supreme Court have given the major importance of the TRI, the controlling authority of telecom. When such jurisdiction issues arose, the writ petition would clearly be maintainable. Telecom Regulatory Authority of India Act 1997 silent feature are also discussed here. If question is here, what are the silent feature of the Telecom Regulatory Authority of India Act 1997? So Competition Commission of India versus Bharti Airtel Limited and others should be written. And then you can find that in head notes, and then you can write that silent features. Now, case number 52, friends. This is a very interesting case for me because as I am insolvency professional, this is case related to insolvency. And my first book, when COVID started, at that time I completed my first book. My first book was on Insolvency and Bankruptcy Code 2016. In that book, I have given 35 leading cases of Supreme Courts. And after that, so many books are there, but that was my first book. So I love insolvency. And as an insolvency professional, after completion of 10 years practice in a legal field, you can give that examination of insolvency professional and you can become insolvency professional. That is administrative job. Liquidator, IRP, RP can become good remunerations are there, but that examination is very tough for lawyers. It is little bit easy to charter accountant, but very few people are getting clear that examination, which is very hard. I myself failed 8 times in that examination. At 9th attempt, I passed. So this is the scenario. I'm not threatening you. Maybe I'm a dull man, so I need 8 attempts. But with the blessing of my guru, Nani Palkiwala, I am trying to do the best, whatever time I got. Okay. जो भी टाइम मिलता है मैं उसमें कुछ तो कुछ करते रहता हूँ, मुझे अच्छा लगता है उस सब चीजों. Don't forget to listen my next Wednesdays, coming Wednesdays, नानी पालके वाला वेनेसडे लॉ क्लब. 1 घंटा 1.5 घंटा निकालो, इवन दो योर एग्जामिनेशन देयर, क्योंकि भारत का लेबर कोड बदल रहा है, लेबर लॉज बदल रहा है, नए कोड आ रहा है, और द कोड ऑफ सोशल सिक्योरिटी 2020 उसमें का एक कोड के ऊपर मेरा पूरा नानी पालके वाला है उसने. यू कैन अंडरस्टैंड. अनऑर्गेनाइज लेबर भी उसमें आ रहा है. आपकी झाड़ू वाली पोछा वाली जो रहती है ना, सफाई करने वाली, वो भी आएगी अभी कानून के इसमें. दे विल आल्सो गेट ए बेनिफिट. कॉर्पोरेट, नॉन कॉर्पोरेट, सेमी कॉर्पोरेट, सबको. इसलिए विच इज वेरी गुड फॉर प्रैक्टिस इन लेबर कोर्ट लाइक दैट. Gradually appeal will comes to the High Court, Supreme Court, then we have to handle that. Whether you like or not, you should update it with latest updated laws of our Eastern country. So it is my humble request. Try to attend lively. बाद में वीडियो सीरियसली नहीं देखा जाता. आज देखो आप पूरा 3 घंटा बैठ रहे हैं मेरे सामने. 3 घंटे में कितना रिवीजन होगा. ठीक है, इसको मैं 2 सेशन का करके अलग अलग वीडियो डाल दूंगा यूट्यूब पे. जैसा सेशन 1 डाला, सेशन 2 डाला, सेशन 3 डालूंगा, सेशन 4 डालूंगा. लेकिन सेशन 3, सेशन 4 बाद में जब आप वीडियो यूट्यूब पे देखेंगे, एट अ ग्लांस 1 घंटा नहीं देख पाएंगे. बीच में डिस्टर्ब होगा, कॉल आएगा, सब आएगा. सो डोंट फॉरगेट टू अटेंड लाइवली. अगर लाइवली मिस होता है तो फिर आप रिकॉर्डेड वीडियो ले सकते हैं, डाउनलोड कर सकते हैं, कुछ भी कर सकते हैं. नाउ this case number 52, Swiss Ribbon versus Swiss Ribbon Private Limited versus Union of India and others. This case is depend upon Insolvency Bankruptcy Code section 5, section 7, 8, 9 and all code of conduct discussed. बहुत अच्छा judgment है, very nice. I salute to RF Nariman and Navin Sinha to give such type of a great judgment. और मेरी छोटी छोटी वीडियो है सेक्शन 7 पे, सेक्शन 8 पे, ऐसे अलग अलग वीडियो इंसॉल्वेंसी की जरूर देखना. इफ यू आर इंटरेस्टेड इन कॉर्पोरेट लॉ, इंसॉल्वेंसी लाइक दैट, एनसीएलटी प्रैक्टिस, एएलटी प्रैक्टिस, ये सब प्रैक्टिस में ये लॉ, कंपनी लॉ, ये लॉ बहुत जरूरी है. RDDBI, most of all corporate law I have covered that videos. You can see that for better understanding. And many of my videos are Hindi and English. क्योंकि क्या है, सच बताऊं क्या आपको, ये इंग्लिश है बाद में हमको है. हम तो मराठी मीडियम में पढ़े 10वीं तक. इंग्लिश थोड़ा सब्जेक्ट था, नहीं ऐसा नहीं, लेकिन आफ्टर इन लॉ, इन ग्रेजुएशन बीकॉम करते समय इंग्लिश में किया, तो इंग्लिश वो. इसलिए हमको थोड़ा हिंदी बोलने में या मराठी बोलने में जितना इजी लगता है उतना शायद इंग्लिश में नहीं लगता है. बट एडिक्वेट जो उतना नॉलेज चाहिए उतना है. थोड़ा बहुत ग्रामर मिस्टेक होता है तो जजेस भी एडजस्ट कर लेते हैं, बिकॉज दे आर आल्सो फ्रॉम मदर टंग बैकग्राउंड, सो दे आर एडजस्टिंग, नो इशू. बट योर कम्युनिकेशन शुड बी पावरफुल. इफ योर कम्युनिकेशन इज पावरफुल एंड डोंट बॉदर अबाउट द फोनेटिक्स. साउथ इंडियन आदमी अपना फोनेटिक नहीं बदलना, तो व्हाई वी शुड चेंज आवर फोनेटिक. माय फोनेटिक स्टिल इज लाइक मराठी, बिकॉज मराठी इज द डोमिनेटिंग लैंग्वेज. So my phonetics is matched to Marathi. I don't want to copy to the US phonetic. वो US phonetic वो मूवी देखते साला समझता नहीं कुछ, इसलिए वो नीचे का लाइन पढ़ के समझना पड़ता है. What did this use that? crystal clear pronunciation should be there. So everybody can understand what you are saying. This is my opinion. I'm not bothering my opinion. If you want to use that accent, you can use. That is your freedom. But even though you are Marathi medium or Hindi medium or Urdu medium student, don't bother about the English. Don't take it as an inferior. No, confidently you are good. No, you will win. Definitely. So, friends, in this case, constitutional validity, provisions of code passes constitutional muster. Section 5, 7, 5, 8, 5, 20, 7, 1, 7, 4, 7, 5, 8, 9. Classification between financial creditor and operational creditor. Whether discriminatory, arbitrary, and violative of Article 14 held. Preserving the corporate debtor as a going concern while ensuring maximum recovery for all creditors being objective of the code. Financial creditors are clearly different from the operational creditors. Thus, there is an intangible difference between the two, which has the direct relation to the object sought to be achieved by the code. What is insolvency? What is this? For that, you understand watch my different videos. Here, this is not platform to explain you what is insolvency like that. I'm explaining you only the content matter of that case. Triggering of insolvency resolution process by financial creditor and operational creditors. It is also discussed here. Submission that the difference in the triggering process at benefit of the financial creditors and the operational creditors is discriminatory and arbitrary. Section 12A as amended and 60, section 60. Section 12A, wherein withdrawal of application admitted under section 7, 9, and 10 with approval of 90% voting share of the committee of creditors is also discussed here. Section 18, 41, 42, and 28, resolution professional. Adjudicatory power, resolution professional, that is IRP, RP, liquidator. These are the three posts. It is commonly called IP, insolvency professional. Adjudicatory power under the code and regulations. Held, it is clear from the code as well as the regulation that the resolution profession has no adjudicatory power. Resolution professional is giving administrative as opposed to the quasi-judicial powers. A quasi-judicial post. Liquidation, जब आप liquidator बन जाते हैं ना, that time you have a different power. But when you are IRP, I'm working for few companies as IRP, RP, and few companies for liquidation. Any case we are handling. I was the first member in my Supreme Court Bar Association who cleared this examination. At this moment, there may be a 2-3 only in these huge 25,000 members who are the IP. But because this is a very hard examination, and day by day it is going on harder and harder, like that. But if you like that, you can get it. A CA also can become CS, CA, and advocate who have more than 10 years back. They can give that examination. They can become insolvency professional. फिर lawyers ऐसे insolvency professional के आगे पीछे घूमते रहता है. So this is, and good remuneration, everything is good. Like that. Section 29A and section 35(1)(f) proviso. Section 29A, if restricted to malfeasance submission, that section 29A puts a blanket ban on participation of all promoters of corporate debtors and without any mechanism to weed out the unscrupulous as against the efficient manager, but who have not been able to pay off their debts due to other reasons. It is held by Apex Code Section 29A, not restricted to the manifest legislative purpose which permitted Section 29A continues to permit the section when it applies not merely to resolution applicant but to liquidationers. 29A is applicable to not only resolution applicant but in liquidation also. So this is the special outcome of this Swiss River. Section 29A, exemption of micro, small and medium enterprises from Section 29A. Jurisdiction of. It is held by Apex Code justified, rational for excluding such industries from the eligibility criteria laid down in Section 29A. See, मैंने अभी Section 29A के ऊपर वीडियो नहीं बनाया, लेकिन I will prepare that video. So जैसे जैसे टाइम मिलेगा वैसे वैसे बनाते रहते, कोई टेंशन don't put it. 29AH is because and industries other resolution applicant may not be forthcoming when they will inevitably lead not to resolution but to liquidation. Micro, Small and Medium Enterprises Development Act 2006 also discussed here. Distribution of assets, submission, that everything is discussed. Object and reasons of this insolvency code is also explained in this judgment. Companies Act 2013, Section 412, selection of members of tribunal and appellate tribunal also discussed here. So very nice. Yes, Sanjo Engineering and Construction Company Limited versus National Highway Authority of India, May 8, 2019 is our 53rd leading case. Arbitration on the, this is again on arbitration. Arbitration bid for construction of the 4-lane bypass on National Highway 26 in Madhya Pradesh, MP. So National Highway 26 4-lane bypass construction bid related to arbitration. So this is in S. Sanjog Engineering and Construction Company Limited versus National Highway Authority, that is called NHAI. So 2 judges bench is there. Arbitration and Conciliation Act 1996. You will find my one video on that and one separate Nani Palkiwala law club also. And one I have taken one interview of the senior lawyer Jaydeep Gupta. Jaydeep Gupta is my best friend in Supreme Court, and he have the very good command on international and national arbitration. So you will find in Nani Palkiwala playlist one interview I have taken of Jaydeep, senior law advocate Jaydeep. You should watch that to understand international arbitration. Section 34(2)(b) to 34(2)(a)(3). Respondent invited bids for construction of 4-lane bypass on National Highway 26 in the state of Madhya Pradesh. Appellant's bid was accepted. Price adjustment for 4 of the components used in execution of the contract, that is cement, steel, plant and machinery, and other local material was to be calculated as per the formula given in subclause 73 of the contract. Appellant challenges the circular. Eventually, the arbitral tribunal consisting of the 3 members by majority award held that the circular could be applied as it was within the contractual stipulation. Petition under section 34 filed by the appellant. Generally, arbitral award cannot be challenged in High Court and Supreme Court. So this is a great protection given for arbitration mechanism. But under section 34 of Arbitration and Conciliation Act 1996, if under 34 only, if it is fit, then it can be admitted in apex court. So petition under section 34 filed by the appellant, rejected by the High Court. Appellant inter alia pleaded that section 34 2B2 was attracted as the award was in conflict with the public policy of India, and section 34 2A3 would also be attracted as a principle of natural justice were violated. What apex court held? Government guidelines that were fed to and replied upon by the majority award to arrive at the thinking factor were never be evidence before the tribunal. Tribunal relied upon the same guideline by itself, stating that they are to be found on a certain website. These being the case, the appellant would be directly affected, not being allowed to the comment on the applicability and interpretation of those guidelines. Thus, majority award set aside under section 34 to A3. Further, it orders to apply a linking factor, a circular unilaterally issued by the one party cannot possibly bind and the other party to agreement without any other party's consent. Foreign Award Recognition and Enforcement Act 1967 is also discussed here. But very important one thing I want to mention here. Unilateral model law of international commercial arbitration. Article 26. If you want to get the mastery on arbitration and conciliation system, you should read this unilateral model law of international commercial arbitration. This is international law. And many sections, many provisions of that international law we have taken in our 1996 Act. So Arbitration and Conciliation Act 1996, Section 34, setting aside an arbitral award is conflict with the public policy of India. Law Post Amendment Act 2015 held by Apex Code public policy of India, whether contained in Section 34 or Section 48 of the 1996 Act, would now mean the fundamental policy of Indian law as explained in paragraph 18 and 27 of Associate Builder case. That is, the fundamental policy of Indian law would be relegated to the Renusagar understanding of the expression. Expansion of the phrase public policy of India made in Western Sego case has been done away with. So Western Sego is also explained here. Interesting case for arbitration matter. Now, case number 54. Dr. Ashwini Kumar versus Union of India and others. September 5, 2019. This case is depending upon custodian torture. Article 21. Separation of power and no direction when matter is pending. So these 3 points are in this case. Three judges bench, custodian torture, writ petition filed under Article 32 of the Constitution, seeking effective and purposive legislative framework, law based upon the Convention Against the Torture and Other Cruel, Inhuman, and Degrading Treatment and Punishment adopted by the United Nations General Assembly. Prayer of applicant was that custodian torture being crime against humanity which directly infringes and violates Article 21, this court should evoke and exercise jurisdiction under Article 141, 142 for protection and advancement of human dignity, a core and non-negotiable constitutional right. It is held by Apex Court. It is true that in some extraordinary cases where notwithstanding the institutional reason and the division of power, the court has laid down general rule guidelines when there has been a clear, substantial, gross human rights violation, which significantly outweigh and draw any legitimacy concerns based upon separation of power, lack of expertise, and unnecessarily of the consequences. Any direction at this stage would be interpreted as judicial participation in enactment of law. So, when the matter is already pending consideration and being the examined for the purpose of legislation, it would not be appropriate for this court to enforce its opinion, because that is under the process of parliament to enactment of that law. So when that is in process, so judiciary should not interfere in that. So judiciary, administration, and legislation. Judiciary, administration, and legislation. These are the 3 poles of our Loktantra. So legislation is when they are in the process of enactment. So judiciary should not give any opinion. So this is the separation of power, doctrine of separation of power. Not be appropriate for this court to enforce its opinion, be it the form of a decision or even a request, for it would clearly undermine and conflict with the role assigned to the judiciary under the Constitution. No direction can be given to the executive to ratify the UN Convention, for it would be virtually human right violation, Human Right Union Convention on Human Right. That document is there. You can download it from the website. That is also very good. All our fundamental rights, everything is a design according to the international convention. Constitution of India, Article 21, 32, 141, 142, Constitution of India, separation of power, everything is discussed in this. Powers and function of legislation also discussed in this. Doctrine and principle, doctrine of separation power, already I have mentioned. Distinction between interpretation and adjudication by the court on one hand and power to enact legislation by the legislation on the other. Such interpretation is called judge-made law, but not legislation. Case number 55, Roger Matthew versus South India Bank Limited and others. November 13, 2019. This is on Tribunals, Finance Act 2017, 5-judge bench. Tribunals, Finance Act 2017, a money bill or not under Article 110, validity of Act 2017. Whether that act is valid, Tribunalization Act or not, it is the question here. What is held by the apex court? The majority in case Puttaswamy, Aadhar 5, pronounced the nature of the impugned enactment without first delineating the scope of Article 1101 and principle of interpretation of the repercussion of such process. The majority dictum in K.S. Puttaswamy Aadhar 5 did not substantially discuss in the effect of the word only in Article 1101 and offers little guidance on the repercussion of a finding when some of the provision of an enactment passed as a money bill do not conform to Article 1101A(b) without expressing a firm and final opinion. The analysis in K.S. Puttaswamy Aadhar 5 was made it application difficult to present case and raises a potential conflict between the judgment and coordinate branches. The objects of the parent enactment as well as the law laid down by the Supreme Court in R.K. Jain, L. Chandra Kumar, R. Gandhi, Madras Bar Association, Gujarat Urja Vikas undoubtedly bind the delegates and mandatorily required delegate under Section 184 to act strictly in the conformity with this decision and objects of the delegated legislation stipulated in the states of tribunal. Therefore, the union government directed to carry out an appropriate exercise for amalgamation of existing tribunal, adopting the test of the homogeneity of the subject matter to be dealt with and thereafter constitute adequate number of benches commensurate with the existing and anticipated volume of work. Tribunals, tribunalization, a global trend discussing this matter. Case number 56, Central Public Information Officer, Supreme Court of India versus Subhash Chandra Agrawal, November 13, 2019 case. RTI, Collegium System for Appointment and Elevation of High Court and Supreme Court Judges. Whether it is RTI applicable or not. 5 judges bench. Right to Information Act. That is very powerful act. Anna Hazare. Collegium System for Appointment and Elevation of Judges to the Supreme Court and High Courts. Declaration of assets by the judges, etc. Information in contents. The respondent filed the 3 applications under RTI Act 2005 seeking information regarding 1. Copies of the correspondence exchanged between constitutional authority together with file noting relating to the appointment of 3 judges of the Supreme Court who had superseded seniority to another 3 judges by an application dated 23/1/2009. A copy of resolution dated 7/5/1997 of the judges of Supreme Court requiring every sitting judge and all the future judges upon assuming office to make a declaration of the asset by the application dated 10/11/2007. And 3, on the basis of a newspaper report, the complete correspondence exchange with the Chief Justice of India in regards to Union Minister having allegedly approached a judge of High Court through a lawyer to influence the judicial decision by an application dated 6/7/2009. There's a question आता है, what applicant demanded, which 3-point demanded. That time you have to mention this 3-point properly. Held by the apex court in this matter, the information sought by the respondent in application dated 10/11/2007 regarding declaration of the assets judgment of the full bench of the High Court is upheld, which had upheld the order passed by the CIC directing the CPIO Supreme Court to furnish information on the judges of Supreme Court who had declared their assets. Such disclosure would not in any way impine upon the personal information and right to privacy of the judges. The fiduciary relationship rule in terms of CLE 2, Section 8(1) of the RTI Act is inapplicable. It is unbeatable that Supreme Court is a public authority as defined wide CLH 2, Section 2 of the RTI Act, as it has been established and constituted by and under the Constitution of India, the office of Chief Justice or for that matter of the judges is not separate from the Supreme Court. The office of Chief Justice and Supreme Court is not separated. It is the part and parcel of the Supreme Court as a body, authority, and institution. The Chief Justice and Supreme Court are not two distinct and separate public authorities, albeit and latter in a public authority, and Chief Justice and judges together form a constitute and public authority, that is Supreme Court of India. Judicial independence also given here. I will take one separate video. I will prepare a separate 5 to 10 minutes video on information, Right to Information Act also. And in future, I will take one Nani Palikiwala separate 1 hour, 2 hour show on Right to Information Act in detail with some leading case laws of Supreme Court. Case number 57. This is also insolvency case. Committee of Creditors of SR Steel India Limited through authorized signatory versus Satish Kumar Gupta and others, November 15, 2009. IBC, power of COC. Here, wisdom of COC, Committee of Creditors. Wisdom of COC is very important, and that should be intact. It is main output. No discrimination between financial creditor and operational creditor. And RP, resolution professional role, is also mentioned. 3 judges bench. Insolvency and Bankruptcy Code 2016 Corporate Insolvency Resolution Process. You can watch my separate video on corporate insolvency resolution process, liquidation process, everything. Power of Committee of Creditors to approve the resolution plan. On fact, resolution plan for corporate debtor SR Steel India Limited in CIRP of corporate debtor. ArcelorMittal India was successful resolution applicant. Resolution plan of ArcelorMittal specifically providing for an upfront payment of Indian rupees 35,000 crore in order to resolve debt amounting to NRI 42,213 crores. In the practice of Supreme Court, we are reading only these figures. But as an insolvency profession, we are handling such type of transaction. When we are liquidating one company, liquidating the assets, we are handling that. Because this is administrative. Chartered accountant are with us. We can hire lawyers, we can hire chartered accountant, we can hire expert, and we have to complete that in speculative time. Time frame is very important in IBC. Such time frame should be there in every law. Then tarikh pe tarikh can be avoided. So this is a very different code and different law, friends. Insolvency and bankruptcy code. Bare Act is small, but I have two bigger volumes. Where is that? Insolvency. Upper side. Insolvency, criminal law, POSCO, NDPS Act, criminal laws. Yes, insolvency. There is that. Two volumes. Commentary is very important when you are arguing in NCALT. NCALT is after NCALT appeal is direct to Supreme Court. So NCLT, NCALT, NCLAT, and then Supreme Court. So when you are arguing in appellate tribunal and Supreme Court, that time commentary is very important. When you are dealing in NCLT only, that is a trial court. That is regular of our CPC provisions are there, and there is a practice of lawyer there. Resolution plan. Approval of final resolution plan of ArcelorMittal by Committee of Creditors, initiation of several proceedings. NCLT allowed the resolution plan. NCLT trial court allowed resolution plan. Challenge to before the NCLAT. NCLAT, that is called NCLAT, held that there can be no difference between a financial creditor and operational creditor in the matter of payment of dues. Thus, NCLAT redistributed the proceeds payable under the approved resolution plan as per the method of calculation adopted by it, so that all financial creditors and operational creditors be paid 60.7% of their admitted claims. But in appeal ordered by NCLAT, which substitute its wisdom for the commercial wisdom of the Committee of Creditors and also directs the admission of the number of claim which was done by the resolution applicant is set aside. CIRP of the corporate debtor will take place in accordance with the resolution plan. ArcelorMittal dated 23/10/2018 as amended and accepted by the Committee of Creditors. One more thing it's discussed in this resolution professional role of its revival corporate debtors. Role of resolution professional is not adjudicatory, but it is administrative. Adjudicating authority cannot interfere. Adjudicating authority means NCLT. Adjudicating authority cannot interfere on merits with the commercial decision taken by the Committee of Creditors. The limited judicial review available is to see that the committee of creditors has taken into account the fact that corporate debtor needs to keep going as to going concern during the insolvency resolution process, that is needs to maximize the value of the asset. Equitable treatment also discussed here. Extinguishment of personal guarantee, undecided claims also discussed here in this judgment. Now, case number 58. Messrs. Shanti Conductors Private Limited versus Assam State Electricity Board and others. December 18, 2019. Friends, this case is depend upon the CPC, Civil Procedure Code Order 47, Rule 1, Review and Limitation. 3 judges bench. Order 47, Rule 1, Review Petition. Error apparent on record. On facts review petition on the ground that there is an apparent error in the judgment by this court holding that suit was barred by the time. Petitioner's case that in money suit pertaining to the interest on principal amount received by the petitioner, the last supply was completed on 4/10/93, but the last payment was made on 5/3/1994. A fresh period of limitation would begin from 5/3/1994 on the basis of Section 19 of the Limitation Act. Limitation Act, Evidence Act, CPC, CRPC, IPC, Contract Act, and Constitution of India. Thus, regularly read at least index read, so you can remember the section like that. Don't do practice such type of practice only when matter is coming. That time you are studying these cases and section. This is ground. Even though you have the matter or not, you routinely at least read the index of that particular IPC, CRPC, like that. And when you get the interest, you automatically. This is my regular habit. I'm traveling by metro from my new Ashok Nagar office to Supreme Court. While going by metro, 20 minutes. While coming by metro, 20 minutes, where I am getting to read it. Anywhere, airport पे जाता हूँ, I will not catch any cab. कभी कैप नहीं करूंगा. कैप करूंगा तो वो हिलती कैप तो I cannot read. This is the wastage of time of minds for 1 hour. पैसा जाता है वो छोड़ दो, पैसा का कोई टेंशन नहीं है, but 1 hour wastage. So I am always traveling by metro. Metro से बैठता हूँ, पटाख से फिर पढ़ते रहो. Change metro at Raju Chowk, then catch the yellow line, one station, then New Delhi से express metro line में जाती है. When metro is not available at midnight time, that time I am catching the cab, otherwise not. So I am not telling about the metro cab like that. My main purpose is that find time to read, and whenever you get the time, read constantly. I have the Manupatra. So Manupatra, log in Manupatra, take one bare act and read them. Both knowledge बढ़ता है. Hindu Marriage Act, Hindu Succession Act. I have all videos on my YouTube. You can watch my videos. You can hear my videos. You can hear different videos also. Different channels, Oxford, Harvard channel is also there. Law School channel is also there. Bombay High Court channel is also there. Supreme Court Bar Association channel is there. You will get the tremendous light. But if we are not getting this benefit in this era, then whose fault it is? So friends, so this is a CPC provision. And Supreme Court held exemption provided under section 4 to 20 of the Limitation Act are based on certain facts and events. On the facts pursuant of the plaintiff indicates that there is no pleading as to exception of limitation by running any fresh period of limitation as per section 19. There was no occasion for defendant to raise any reply in reference to section 19. Issue of benefit of section 14 was specifically considered and rejected by this court in the judgment. Thus, there is no error apart on the said ground. Limitation Act 1963, section 1914, interest on delayed payment to small scale and ancillary industrial undertaking Act 1993. Now, case number 59. Kesham Meghachandra Singh and the Honorable Speaker, Manipur Legislative Assembly and others, January 21, 2020. This case is dependent upon election, disqualification of the candidates. Speaker shall take decision timely. 10th schedule of the Constitution. 3 judges page. Constitution of India, 10th schedule. Disqualification of candidate nominated in Legislative Assembly. Legislative Assembly elections on the ground of defection. The election for the 11th Manipur Legislative Assembly was conducted in March 2017. None of the political parties were able to secure a majority, that is 31 seats in Legislative Assembly of 60 seats in order to form a government. The Congress party emerged as a single largest party with 28 seats and BJP with 21 seats. The respondent number 3 contested as a candidate nominated and set up by the Congress party and was duly elected on 12/3/2017. Respondent number 3, along with various BJP members, met the governor of the state and snagged a claim for forming BJP-led government. Thereafter, the respondent number 3 was sworn in as a minister in BJP-led government. Applications were filed before the Speaker of the Legislative Assembly between April and July 2017, seeking disqualification of the respondent number 3 under paragraph 2(1)(a) of the 10th schedule. No action was taken by Speaker. Such type of judgment give you enlarged, intensely good knowledge of political interferences. बहुत अच्छा judgment है. Held by our apex court. It is clear from the reading of the judgment of the Rajendra Singh Rana and S.A. Sampath Kumar that a failure to exercise jurisdiction vested in Speaker cannot be covered by the shield contained in paragraph 6 of the 10th schedule, and that when a Speaker refrain from the deciding a petition within a reasonable time, there was clearly an error which attracted jurisdiction of the High Court in exercise of the power of judicial review. The only relief that can be given in this instant appeal is that how judiciary is maintaining proper distance with legislation. So see this line. The only relief that can give in this instant appeal is that Speaker of Legislative Assembly be directed to decide the disqualification petitions pending before him within a period of 4 weeks from the date on which this judgment is intimated to him. But decision Speaker should take. Judiciary will not interfere in legislative decisions. So this is a nice judgment. Now, case number 16, Sushila Agrawal and others versus NCT of Delhi and all. For bail matter, this case is very good. Anticipatory bail matter. This is my separate book, Supreme Court case laws on bail matters. And different books are also there on bail matters, but this is, I have covered this case in that book also. Sushila Agrawal and others versus State of NCT Delhi and others, January 29, 2020. CRPC under section 438, grant of anticipatory bail. Life of bail, no restriction. These are the points of this case. Code of Criminal Procedure 1973, section 437, 438, 439 and 167 to order under section 438 granting anticipatory bail. Life and operation of conflicting views of different benches on varying strength as to whether the protection guaranteed under section 438 should be limited to fixed period so as to enable the person to surrender before trial court and seek regular bail. Whether the life of anticipatory bail should end at the time and the stage when accused is summoned by the court. Reference to larger bench. It is held by Supreme Court. Protection guaranteed under section 438 should not invariably be limited to a fixed period. Once bail get anticipatory bail, there is no fixed period. If after 3 months or after summoning by court, the bail is no, it is long lasting. Unless and until accused is breaking the rules formed by the trial court while giving the bail. Bail is not given by High Court, bail is not given by Supreme Court. Remember these things. Bail is always given by the trial court. But when trial court is not giving bail, appeal comes to High Court. When High Court is not giving bail, appeal comes to Supreme Court. But if Supreme Court granted the bail, but Supreme Court give the judgment, I incline this fellow should get the bail, and they are directing to the trial court to take this bond, this limitation, and whatever impose more rules, and trial court decide. Then after that judgment, then trial court giving the bail. Giving the bail is the duty of trial court. So trial court is a very powerful court. So trial court lawyers are also very powerful lawyers. लोगों को लगता है सुप्रीम कोर्ट ने बेल दिया. Supreme Court have given the direction to give the bail to the, when they finds everything is okay and there is a mistake of the trial court not to give the bail. Sometimes High Court is giving the granting the bail. So friends, what is held by the apex court? Protection guaranteed under section 438 should not invariably be limited to a fixed period. It should ensure in favor of accused without any restriction of time. This is the main strength of this case. Normal condition under section 437(3) read with section 438(2) should be imposed. If there are specific facts or features in regard to any offense, it is open for the court to impose any appropriate condition, including fixed nature of relief or its being tied to an event. Whatever condition court is imposing, that condition should follow by the accused. If accused is breaking that condition, that time his bail is in danger. Then it can be cancelled and then arrest procedure will be there. The expression anticipatory bail. No word is anywhere. The expression anticipatory bail has not been defined in the Code of Criminal Procedure. As observed by the Supreme Court in the case of Balchan Jain, anticipatory bail means bail in anticipation of arrest. As held, the expression anticipatory bail is a misnomer in as much as it is not as it if bail is presently granted by the court in anticipation of arrest. Power to grant anticipatory bail under section 438 of CRPC vests only with the Court of Session or the High Courts. Supreme Court, SLP is there. So read my, watch my one video, Jurisdiction of Supreme Court. So you will find the which doors are there to come in Supreme Court. Different type of doors are there. कितना भी बात करो ना, कितना भी करो, थकान नहीं होती है, बिल्कुल नहीं. You are thinking since last 2 hours you are taking this session, but you are not tired. No, why I should tire? Practice in apex court. All over India, peoples are coming to us. And this is a great opportunity for us to serve them, to help them. How then we get the tired? Friend, we are in very good field, in noble profession. This is not a business. This is not a profession. This is a purely public service. So we are getting more respect from society also, from leaders also, from politicians also, from everyone. With ourselves also. When I meet to any lawyer, I get impression in my mind. Ah, lawyer. So friends, such type of noble profession we have. सेवा के बाद मेवा मिलता है. So don't think about मेवा, think about सेवा. Automatic चलता है, बहुत चलता है. कभी-कभी मेरा ये बोलता है, क्लार्क वगैरह बोलता है, सर इतनी मेहनत क्यों कर रहा है, ये डिसमिस होने वाला ही है. बेटी कुछ दम नहीं इसमें. लेकिन नहीं, मेरे पास हर आने वाला हर केस मुझे मेहनत से ही ऐड करना है. और हाईकोर्ट के लॉयर भी इतने अच्छे ना जो जुड़े हैं हाईकोर्ट से, पूरे भारत के हाईकोर्ट से लोग कनेक्टेड है. कुछ हाईकोर्ट के लॉयर इतने डेडिकेटेड है ना, वो बोलते हैं सर बस ट्राई टू गिव द रिलीफ टू द क्लाइंट. हमको कितना पैसा मिलता है वो ऐसे जानने वाले लॉयर बहुत कम है. मेरे क्लाइंट को रिलीफ मिलना चाहिए. बहुत अच्छा लगता है ऐसे लॉयर का फोन आता है. आई एम गेटिंग इंस्पायर्ड. हमारे गुरु बन जाते हैं वो लॉयर हाईकोर्ट के, हमको इंस्पायर करते हैं. व्हाट इज द थिंकिंग? इसलिए आई सैल्यूट टू हाईकोर्ट लॉयर, आई सैल्यूट टू ट्रायल कोर्ट लॉयर, आई सैल्यूट टू तहसील कोर्ट लॉयर. फॉर सच टाइप ऑफ वेरी गुड ऑफ देयर थॉट्स. अब मेरा 59 चला, 60 होगा, 65 होगा. बस जब तक मैं चलता फिरता हूं तब तक आई विल हायर को. बच्चों को बता दिया, मुझे दिल्ली से आप तभी लेके जा सकते हैं जब मेरे हाथ पर नहीं चलेंगे. That time you come and take me at Pune, then I can live with you. Also, very nice bit, and very nice judgment this. Huh? Leading case number 61. Dheeraj Moore versus Honorable High Court of Delhi. February 19, 2020. This case is depend upon Judicial Service, District Judge, Article 233 to 235. 3 judges bench. Constitution of India, Article 233 to 235. Interpretation of Article 233. Eligibility of members of subordinate judicial service for appointment as a district judge against the quota reserved for the bar member by way of direct recruitment. Petitioners who are in judicial service inter alia claimed that there are 2 sources of recruitment under Article 233(2) from judicial service and from the bar. Then a person in judicial service with 7 years experience at the bar before joining the service or combined with service as a judicial officer can compete with member of the bar with 7 years or more experience for direct recruitment in the quota earmarked to be filled by the such advocates. Matter referred by divisional bench of the Supreme Court. Answering in the reference, apex courts held that members in the judicial service of the state can be appointed as a district judge by way of promotion, limited competitive examination. For the purpose of Article 232(2), an advocate continuing in practice for not less than 7 years as on the cut-off date and at the time of appointment as a district judge can be appointed as a district judge by way of direct recruitment if he is not already in the judicial service of the union or state. Members of judicial service having 7 years of practice before joining service or combined with service as a judicial officer are not eligible for apply for direct recruitment as a district judge. Rule framed by High Court against the post reserved for the advocate by way of direct recruitment are not ultra vires and are the conformity with Article 14, 16 and 233. So this is the outcome of this Dheeraj Moore case. So now we are moving towards next case. Cryptocurrency judgment. Next judgment, leading case number 62. Internet and Mobile Association of India versus Reserve Bank of India, March 4, 2020. Virtual currencies, cryptocurrencies, RBI. Is cryptocurrency legalized in our country? This is the answer of this question is in this judgment. You can buy, you can sell cryptocurrency, but as in the form of commodity. As you are buying, selling gold, silver, like that. Commodity, in the form of commodity, you can do that. This is the outcome of this judgment. But you cannot use cryptocurrency as a legal tender. As we are using 100 rupees note, 200 rupees note. As a legal tender, you cannot use that. So this is the outcome. I have given the very short summary of that. Now, try to understand the wording of the apex court. Reserve Bank of India Act 1934, Section 17, 2022, 26, 38, 45JA, 45L, 45U, 45W, 45Z, 45ZO. Reserve Bank of India (RBI) issued a statement on the departmental and regulatory policy dated 5/4/18 and circular dated 6/4/18 respectively, which directed the entities in regulated one not to deal with or provide services to any individual business entity dealing with several virtual currencies VCs, and two, to exit the relationship if they already have one with such individual business entities. This circular was challenged by petitioner, a specialized industry body representing the interest of online and digital services industries, companies running online crypto assets exchange platform. That organization challenged. Shareholder, founders thereof, individual crypto assets traders, enter alia on the ground that RBI has no power to prohibit the activity of trading in VC through virtual currencies exchange, since they are not legal tender but tradable commodities, digital goods, not falling within the regulatory framework of 1934 Act or 1949 Act, and that VCs means virtual currencies, do not even fall under the credit system of the country to enable RBI under the preamble to 1934 Act, giving in a mandate to operate the currency and credit system of country to its advantage. The petitioner extension that VCs are just goods, commodities, and can never be regarded as a real money, and that they are carrying on an activity over with RBI has no power statutory, not accepted like that. Finance Act 2016, banking regulation, some section discussed here. Held by Apex Court, buying and selling of cryptocurrencies through VC exchanges can be by way of hobby or as a trade business. Person who engage in buying and selling virtual currencies just as a matter of hobby cannot pitch their claim on Article 19(1)(g), for which is covered herein are only profession, occupation, trade, or business. So this is the outcome, which I already detailed for you. Currency, currency note, Indian currency, money, regular definition of money. Very interesting case for economic level, who are economic. जिनको economics बहुत अच्छा लगता है. For them, this is a very good judgment. And if you are very weak in economics, this is very good opportunity to learn you what is money, what is currency, right line, what is action. Everything you can understand through one judgment. Read it again, again. This is good judgment for non-economists also to become economist. Leading case number 63, Indore Development Authority versus Manohari Lal and others, etc. March 6, 2020. Right to fair compensation and transparency in land acquisition. These are the 2 points in this case. 5 judges bench. Right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement Act 2013. Legislative history of the Act 2013, purpose of its enactment, silent features, departure from old Land Acquisition Act 2013 Act relating to the social impact of assessment, rehabilitation, and resettlement scheme discussed in this. Twin requirement for the lapse. Firstly, physical possession has not been taken, and secondly, compensation has not been paid. It is held by Apex Code Section 24(2) of the Act of 2013 deals with the situation only where the award has been made 5 years or before or more before the commencement of the act, but physical possession of land has not been taken nor compensation has been paid. Right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013, Section 24(2), interpreting or under Section 24(2) of the Act of 2013, distinctly effect of held. It would result in an anomalous situation because once compensation has been paid to the landowner, there is no provision for its refund. In case physical possession is with the landowner and compensation has been paid, there is no provision in the act for disgorging out the benefit of the compensation. In the absence of any provision for refund in the Act 2013, the state cannot recover compensation paid. Once you have the given compensation, state cannot recover this. Thank you. Thank you for giving such type of good comments on chat box. This is last session. So at the end of session, I will unmute you all. Just whatever you want to give the remarks, what you can share, we share, and get touch with Dani Falkiwala Wednesday Law Club every show. आते रहेंगे, होते रहेंगे, कुछ बातें हम आपसे सीखेंगे, कुछ बातें हम आपसे बताएंगे, करते रहेंगे बस. Now, last case, leading case number 64, Madras Bar Association versus Union of India and others, November 27, 2020. This is case also again for tribunalization, National Tribunal Commission. 3 judges bench. Tribunal, appellate tribunal, and other authorities, qualification, experience, and other conditions of service members, rules 2020. National Tribunal Commission, Constitution of India. All these are connected in this case. What held by the Apex Court in this case? The Union of India directed to constitute a National Tribunal Commission which shall act as an independent body to supervise the appointment and functioning of tribunals, as well as to conduct disciplinary proceedings against members of tribunal and to take care of administrative and infrastructural needs of the tribunals in an appropriate manner. Till the National Tribunal Commission is constituted a separate wing in the Ministry of Finance, Government of India shall be established to cater to the requirement of the tribunals. So because of this judgment, tribunalization become very strong. Proper system, proper procedure, practical process is set. Tribunal, appellate tribunal, and other authorities, disqualification, experience and other condition of service members 2020, search cum selection committee, composition of Apex Court held that the search cum selection committee should comprise of the following member. Question आएगा इसके ऊपर. Following member: 1, the Chief Justice of India, who is appointing the members of tribunal. So who are the member of this committee? National Tribunal Commissions. Who are the member of this National Tribunal Commission? I am discussing at here. I am not discussing, judges are discussing here. I am just a media. The Chief Justice of India and or his nominee, he is a chairperson of this committee with a casting vote. Second, outgoing chairman or chairperson or president of tribunal or sitting chairman or chairperson or president of tribunal in case of appointment of other members of the tribunal, a retired judge or a retired judge of Supreme Court of India or a retired Chief Justice of a High Court in case of chairman or chairperson or the president of the tribunal is not a judicial member, or if the chairman or chairperson or president of the tribunal is seeking reappointment, member. Third, secretary to the Minister of Law and Justice, Government of India, member. Four, secretary to the Government of India from a department other than the parent or sponsoring department nominated by the Cabinet Secretary, member. Secretary to the sponsoring or parent ministry or department, member, secretary, governor. So such type of very fantastic opinion output is given in this case. And their age limit, chairman's age limit is 70, chairperson limit is 70. So after retiring from Supreme Court as a judge at the age of 65, they can work as a chairperson of NCALT or equivalent appellate tribunals. ITA, that Income Tax Appellate Tribunal, like all these appellate tribunal chairpersons, age of retirement is 70. So they can work at fine. So many Supreme Court judges are finding as chairperson in NCLT many times. So we are not missing them. When they are retiring, we feel very bad. But when we saw some of them as a chairperson of appellate tribunal, we get very happy. And then house rent allowance, everything is discussed in there. Chairperson's house rent allowance like that. Members of Indian legal services, eligibility criteria, everything is discussed here. Removal of members. Retrospective of 2020 rules. So everything is clear. Official Gazette published in that is a 12/2/2020 cannot be given retrospective effect. The intention of the Government of India to make the rule 2020 rules prospective is very clear that notification dated 12/2/2020. In any event, subordinate legislation cannot be given retrospective effect unless the parent statute specifically provided for the same. It is clarified that all the appointment made prior to 2020 rules, which came into force on 12/2/2020, shall be governed by the Parent Act and rules. Any appointment made after the 2020 rules have come into force shall be in accordance with the 2020 rules, subject to the modification directed in the preceding paragraphs of this judgment. So, friends, actually, this book is near about 195 to 197 pages. Okay, so it is not possible to read all these pages, but in this near about 200 pages, I try to compile the glimpse of the head notes of all 64 cases. And I'm not interested in giving AOR examination because in my law firm there are 5 AORs with me. If I become AOR, then what about them then? So I'm interested in arguing counsel. In which age you are coming to Supreme Court? That is very important. If I had come at the age of 24, 25, definitely I will become, I would become AOR, because for new person to become AOR is very good to establish in Supreme Court practice. But when you come to Supreme Court after High Court establishment, everything at the age of 54, I come here. So that is not age of filing everything, no. That is the age of arguing. So I become arguing counsel here. So many lawyers are hiring, many lawyers are taking the giving advice, taking advice, checking whether they're thinking or correct or not, and discussing. And many times I am getting very good knowledge from them also. So this happens. And from all of you who are in working in Supreme Court, I am regularly coming to Supreme Court. So we will have a word. Generally, I'm when I'm a little bit free, so I'm near to first floor cafeteria area, and otherwise I'm always in any court, because I love court, I love argument, I love judges, I love everything. So मैं मैक्सिमम कोर्ट के सामने ही बैठा रहता हूँ, लेकिन जब भी फ्री हो जाता हूँ बाहर थोड़ा आ जाता हूँ, लंच आवर में इधर उधर. Yeah, so this is my way of working. I want to thank you for keeping your audience here. मैं तो ये इतना बोर सब्जेक्ट रहता है थोड़ा सा, तो इतना देर कौन रुकेगा, ये थोड़ा सा सवाल मुझे शुरू में था. मुझे लगा कि मैं आखिरी वक्त तक ओनली आई विल स्टे अलोन. नहीं, आप सब रुके हैं, बहुत अच्छा लगा मुझे. और मैं ऑथोराइजली अभी रिकॉर्डिंग बंद करूंगा, फिर हम थोड़ा सा अनऑफिशियली बात करेंगे. तो थैंक यू वेरी मच एंड ऑल द बेस्ट फॉर योर एओआर एग्जामिनेशन. और देते रहो, काम करते रहो, प्रैक्टिस करो, लिखने का प्रैक्टिस ज्यादा करो, राइटिंग स्पीड बढ़ाओ, रीडिंग स्पीड बढ़ाओ, क्वेश्चन पेपर प्रॉपरली रीड करो, और स्पेसिफिकली इन ड्राफ्टिंग पेपर टेक केयर ऑफ दी to cover the all questions, and in Supreme Court rules mention properly rules, properly mention the case laws also wherever possible. If you don't remember the citation, only mention the name of the cost title, any name, Cheras Sarda case, like that you can mention it, that, but mention the case laws. That will give the more impact on the examiner. And in leading cases papers, specifically in leading cases, what is the nature of that case and what are the contents of that case? You try to write one paragraph at first and then give the answer which question they are asking. And everything is given in head note. हेड नोट में फटाक से नजर मारेंगे, ये इसमें डॉक्टर नहीं है, डॉक्टर नहीं है, डॉक्टर नहीं है, फटाफट लिख दो, ये डॉक्टर कवर्ड इन दिस, and one paragraph and another paragraph, then write that. So that will give impact. You have properly studied, properly written. And my best wishes to all of you to get clear this examination and try to become a part of the apex court and to giving the delivery, justice delivery system of our Supreme Court of India. Thank you very much.